I'm attorney Jacob Ayler of the Law Office of Riley and Ayler PC. Coming to you now. We're now in February of 2020. Things are starting to settle down. We've actually just moved to our new location. And, probably the biggest call that I get, number one call that I get to my office day in, day out, and I wanted to make a video about it, is when it is appropriate or when it's right to ask for a change of custody. For those of you that have a paternity case or a divorce case where there's been a previous order by a court as to who has custody of the child, there are times where you may want to change that order. And there are two types of custody that have to be considered. One is what's known as legal custody. What this looks at is the ability of that parent to make decisions about child rearing, things like religion, education, medical treatment, those sorts of things. Then there's physical custody, which is looking at who actually has the child living with them on a regular basis, while the other parent would have some sort of visitation right, however the court ordered that. And the reason I want to talk about this is I've had a lot of clients recently that have been calling my office or have dealt with other attorneys, and they're asking for a change of custody, but a lot of times they don't understand what you actually have to show. Changing custody is not appropriate or is not going to work if you don't meet your burden. And the burden is, it's really twofold. One is you have to show that it's in the best interest of the child. And that's probably the biggest concern that the court's going to have is this move or is this change of custody what is in that child's best interest? Because if you can't show that, it really doesn't matter getting to step number two. Step two is you have to show that there has been a substantial change in circumstances. And the case law discusses it even more in depth, saying that the substantial change in circumstances is significant enough to where the current order that's in place would be unreasonable. And this is one that I think a lot of people fail to understand what that truly means, because so many times I get phone calls or emails or letters from people that will say, well, so-and-so, or my ex-husband or my ex-wife got a new girlfriend or boyfriend and I don't like that person. Or, hey, they put something nasty about me on Facebook and I don't like that person saying those things. So I'm going to go out and get a change of custody. If that is the sole purpose or sole basis for your wanting to change custody, that's going to be a very short hearing, because you have to be able to show that certain elements of law have changed to where it's appropriate. And I want to talk through a couple of these. There's 8 of them, that there are 8 factors that a court will consider. One factor is the age of the child. Are we talking about a 2-year-old who may need special care, or are we talking about a 16 or 17-year-old child? The court will look at the wishes of the child so long as the child is at least 14 years of age. And the reason for that is that, there are times where a child may want to go live with a certain parent because one parent may have more rules than the other parent. That doesn't mean that we should grant custody to a parent because the child thinks they can get away with more if they live with one parent over another. So by age 14, the court will give some weight to that. One element that I do find kind of funny is the court will actually look at the wishes of the parties of each parent. But kind of the oxymoronic thing about that is the parents 99 times out of 100 are going to have different wishes, which is why you're in court in the first place. But that is something the court looks at. The court looks at history of domestic violence between the parties. If there's one party that has a history of domestic violence or has been a victim of domestic violence, the court is going to give significant weight to that sort of situation, because naturally we don't want children in danger or in situations where they're likely to encounter domestic violence. Another factor the court considers is the health, whether it be mental health or physical health of the child. Is the child with a parent who has a lot of experience taking care of a child with special needs or a handicap or a disability, where the other parent may not have that experience? And there are several other factors that the court will consider, but those are some of the big ones. So I always would just tell you, when you go to see an attorney and you have interest in seeking advice about whether you should change custody, you really need to talk about these types of factors, because unfortunately, I get petitions all the time across my desk where people will file for a change of custody, but they clearly haven't thought this through, and it's not a time to ask for a change of custody just because somebody made you angry or upset or you don't like them. That's not a reason. But far often enough, that's exactly what happens. So you want to make sure that you talk to an attorney who understands these elements and have tried these cases before. If you have questions and you would like to come in and talk about these types of cases and whether or not you're in a position that would warrant a change of custody, you can certainly shoot me an email at jacob@michaelriley.lawyer, or you can give our office a call at 219-866-3435 and make an appointment. Be happy to sit down and talk with you about your case. But even if it's not me, you got to just talk to somebody who's experienced in this area so that you know how to proceed going forward. Until next time, thanks.